if we get through 3 and 4, I'll be pleased with that. Because there's a fair amount of math, particularly in chapter 4, and that'll be the first kind of exploration of the math that we've had. So turn to chapter 3, which begins in your book, page 50. Thank you. I've already got you assistant. It's just a second week. All right, so chapter 3 is called Encumbrances. Encumbrances on real property. The word encumbrance is kind of a fancy word. It just means limitation. An encumbrance is a limitation of sorts. So encumbrances can be anything that limit what we can do with a piece of property that we own. So we're still in ownership. We have, as a matter of fact, we're going to stay in ownership for pretty much the whole class. We don't get to leasehold interest until chapter 11. That's so for the next 8 chapters, whenever we're talking about these rights and these privileges and these restrictions, we're always talking about them in relation to owning the properties. Everybody okay with that? All right. So when we talk about encumbrances, an encumbrance is just a limitation on what we can do with a piece of real estate that we what? That we own. Now, last week we talked about this magic type of ownership, which we said was unrestricted in both use and time. What type of ownership is that? Fee simple or fee simple absolute or just fee simple? This is still fee simple stuff. Even with fee simple, there are going to be limitations on the properties. Everybody okay with that? I don't want you to think we've gone into some other area of real estate. We're still talking about fee simple ownership here. Even though there are going to be limitations, I think we all pretty much understand that there are limitations on everything in some way. Or how many of you own property, own a piece of real estate? Are there some limitations on what you can do with that property? Either from the city level or county level or state level. Even if you don't have any of those, you certainly have limitations from a federal level. If you don't believe that, take somebody who lives near RDU Airport and let them put a 500-foot antenna out in their backyard. You will find out just how quickly the federal government limits what you can do with your, because if you own land, you supposedly own what? The air rights above it. So you should be able to just stick a 500-foot antenna out there if you want to talk to, you know, somebody in North Korea for whatever reason.
Or fly drone.
Or fly a drone that you got for Christmas. That's another great example. But if you do that out there near the airport, you're going to get a visit from the Federal Aviation Administration. And they're going to quickly inform you that no, you do not have the right to do that. So this is what we're talking about when we talk about encumbrances. We're talking about these restrictions that can be applied to our ownership. Are we okay with that? So on our slide here, it gives really fancy definition. I like the third one. Any limitation of use is an encumbrance on the property. And almost all of these things, almost, not all, but almost all of them are going to use our favorite new word. What's our favorite word from last week? Appurtenance. These things are almost always going to be appurtenant to the property, which means they're going to do what? Run with the land. But tell me what that means from the standpoint of the people who own the property. It's attached to it, so if I buy the property, I'm also buying the what? The appurtenance or the encumbrance in this case. Does that make sense? So the restriction is going to flow with the property for most of these. I'll point out the ones that are not appurtenant, but the vast majority of encumbrances do run with the property itself, and they are appurtenant. Everybody okay with that? Good. These are examples of encumbrances that we're going to talk about: liens, deed restrictions, lease pendants, easements, and encroachments. We're going to go through each one of these today and talk about them in detail. So let's talk about the first one, liens. Lien sounds like another L word that ends in N. Another 4-letter L word. What does that sound like? Loan. And that's where most liens come from. Most liens began as a loan. So let's distill down what a lien really is when it comes to a piece of property. The kind of liens that we're going to talk about in this class are called specific liens. There's really two big categories. There are specific liens and then there are general liens. General liens are liens against people. If you don't pay your income taxes, you're going to have a general lien placed against you as a person. The reality is that general liens are far worse than specific liens. Because a general lien attaches to you as a person, what assets does it potentially attach to? Everything you own or have any interaction with. If there is a lien against you, then you can't possibly escape it. Does that make sense? A specific lien is much less broad than a general lien, because a specific lien does not attach to you personally. It attaches to a specific piece of real estate. And what that means is that the only thing that can be affected in the long run is that what? That one property. That's the difference between a specific lien and a general lien. Now, don't confuse that with some personal impact as far as like credit scores and that sort of thing. Of course, if you don't make loan payments, that could impact your credit score. But that's not really a legal impact, because a credit score is just an indication of your ability to do what? I shouldn't say your ability and your willingness, right? Because some people have the ability and still don't pay, right? And so credit score is really just a future indicator of whether or not you should be loaned money. It doesn't have any legal impact on you. Having bad credit's not going to hurt you legally. Having a general lien against you is going to very much impact you legally. Does that make sense for everybody? And so I'll give you an example of why. Let's say I am foreclosed on my house. That's a specific lien that attaches to that one piece of property. Yeah, it may ruin my property. But then if I inherit a property from my parents who pass away, that is going to have no impact on that new property that I just came in ownership of. Does that make sense for everybody? Because that lien was only attached to the one property that's now been foreclosed on. Whereas if I have a general lien against me personally, and they take my house, they take my car, they take my bank account, they take everything I own, and it still doesn't pay everything off, and I inherit that property from my parents, is that also going to get tied up in it? Yes. Absolutely. So general liens are much broader. They attach to the person, not to the property. In this class, which one do you think we care about? Specific liens. This is a real estate class, so we care about specific liens. I don't know why that sound effect's there. No earthly idea how that got in there. That's what happens in PowerPoint sometimes. You just get odd things stuck in there. Go ahead, Sharon.
Can the bank put a general lien on the person?
Can the bank place a general lien on the person? So, when you say the bank, give me some more detail.
Mortgage, your mortgage bank, they can put a lien on your
Correct.
property.
A mortgage is a lien on your property.
So, can they put it on the person?
Not a mortgage lien, because a mortgage lien is a specific lien which attaches to the property. Can a bank place a general lien against a person? No, a bank cannot. A court of law can. Generally speaking, only a court of law can place a general lien against a person. How do you think that process begins in a court of law?
By lawsuit.
I heard somebody say you get sued, right? Who would be suing you most likely? Somebody you what? Owe money to. Is a bank someone that you could potentially owe money to? So could they begin the process that would end up with a general lien placed against you? They could, just like any other creditor in the world could. If you owe money to somebody and you don't pay them, their legal rights don't end just because they took the thing that you provided as collateral. With a specific lien, why does it attach to the property? You're providing the property as what? Collateral, that if you don't pay, they can take the property and hopefully sell it and get what? Get their money back. But what if they take the property? So I'm following this to where you're headed. I know where you're headed, but I want to make sure you know where you're headed, right? So if you have a mortgage on a property and you default, meaning you don't pay, what is the bank's first course of action going to be? to foreclose. Does everybody agree with that? They're going to foreclose, which means they're going to take the property, place it for sale, and when it sells, they're going to use the proceeds from the sale to do what?
Pay back the loan.
To pay back the loan. Often, it will not sell for enough to satisfy that note. Because if you think about it, if the property was worth enough that it could be sold and satisfy the note, why the heck did the person end up in foreclosure in the first place? You talk about some really bad financial planning. If you have an asset like a home and it's worth $200,000 and you owe $175,000 on it and you all of a sudden can't make your mortgage payment, it's time to do what? To sell it. Don't sit there and get foreclosed on. That's criminally stupid. It happens, but I mean, it's people don't know, but you see what I'm saying? That's just crazy that happens if you think about it. So presumably, in most cases, in the vast majority of cases, why does something end up in foreclosure? Because they can't pay the mortgage and because the property's what?
Not worth it.
Is upside down, underwater, not worth what is owed. Does that make sense? So that the borrower is trapped. They cannot get out. They can't make the payment. They can't sell the property because it's not worth what is owed. So in most cases, once we go through the foreclosure process, there's still going to be some outstanding balance owed on that note. Does that make sense for everybody so far? It took all of that to get to your question. What can Bank of America do when you still owe them money and they don't have any collateral anymore? Because they've already taken the collateral and sold it. What can they do? They can sue you. And they're going to sue you. And they're going to take you to Wake County District Court, Superior Court, depending on the amount. And they're going to sue you for what's called a deficiency judgment. That last word, judgment. How many of you have ever heard of a judgment? A judgment is a general lien. When you get a judgment against you, you got it in a court of law, and that's a general lien that will follow you. And in most cases, it will prevent you. Is that deficiency judgment ever going to be satisfied?
No.
You don't think so?
Well, I mean,
Do they ever plan to buy a car again? Do they ever plan to buy a house again? Do they ever plan to open a credit card again? Because you know what the first rule for most any creditor on this planet is? Satisfy any outstanding what? Judgments. So 10 years down the road, when that person's finally got their credit back in order, because their credit's going to get fixed, right? Even with that judgment hanging out there, their credit's going to get fixed. And now they want to go buy another house? What is Wells Fargo going to say to them on that mortgage application? You owe Bank of America $22,000 from 10 years ago. You've got to pay it before we will issue this mortgage loan. That's a general lien because it follows, it haunts you as a person. If you win the, do y'all see this kid that won the lottery?
Yes.
You see a picture of him, you really want to vomit. 20 years old. 20 years old. And so like, this is really when I really wanted to vomit. He is 20 years old. First of all, he looks perfect. Like he looks like, I'm like, I hate you already. Not that I'm angry or anything. But he's 20 years old and his hero is some YouTube chef that does this, you know. And so the YouTube chef, of course, has said that she would love to have him be a guest on an episode now. And his response was, I'm so down. I'm like, you don't need $480 million if you use vocabulary like, I'm so down. Talk about a disaster waiting to happen. $480 million and he's so down. Yeah. Yeah, he's lit now, right? Right. I'll give y'all 5-1 odds right now. He's broke in 10 years. What are you? Yeah. But yes, those personal judgments will follow you. And the reason I brought that up is, you know, even if he had one and he wins the lottery, is that judgment going to now get paid? Yes. Because remember, a personal judgment would also represent the right to come back and sue you again, right? And if you ever get to a point in your life when you have money and they find out, are they going to come back after you and renew that judgment at that point in time? None, because they're going to keep renewing that judgment. They follow you forever. Yes, ma'am.
So once that judgment, the general lien, it follows you, once it's sufficed and satisfied, it's paid in full.
Correct.
Does that stop at that point, or does that still follow you?
No, it's gone then. It's satisfied. It's like any other debt at that point. The question was, if I have a general lien and it gets satisfied, is it gone? And the answer is, yeah, it's gone. It's gone. I mean,
So it
it's still
follows you
going to...
until it's
satisfied, until it's paid. And keep in mind that satisfied has various descriptions, because if they have to come back after you again legally, they're going to tack on a bunch of legal fees. Especially if they think you have the money to now cover said legal fees. And you'd be amazed. Yeah. And interest and penalties and all that kind of thing. Yes, sir, Isaiah.
Say if you was to file bankruptcy, would it still follow you?
If you were to file bankruptcy, would it still follow you? I can't answer a bankruptcy question because honestly, I'm just not knowledgeable enough. It would depend on the type of bankruptcy and how things were discharged. And I mean, generally speaking, the point of bankruptcy, and bankruptcy is another thing that in this business you have to be super careful of. You know, people do not understand what they're doing when they file bankruptcy. They look at it as a way to get away from debts. Well, it is. It's also a way to get away from your assets too, because that house that used to belong to you, it's still in your name, but it doesn't belong to you anymore. Because here's what you're telling a court of law. When you declare bankruptcy, you're declaring to a court of law, Your Honor, I am such a moron, I can't handle my own finances. Please take them over. That's what you're saying. That's the legal argument you're making, that I am so stupid I cannot handle my own finances, so I need you, the court, to appoint somebody to handle my finances. And I'm not trying to be insulting about it. I'm trying to make a vivid point about what you're saying. Can that person sell their house? No. Because they just made a legal argument to a court of law that what? I'm too stupid to know if I should sell my house. So who's going to have to decide that the house can be sold? The bankruptcy court. So when you take that listing, you're not dealing with the seller anymore. Who are you dealing with? The bankruptcy trustee, bankruptcy court. It could take forever. Because they have to send letters out to every creditor and make sure they get updated statements of what's owed and where it's owed and how it's going to be paid, because there might be some proceeds involved with this sale. And guess where those are going to go? Not to the seller, I can tell you that. You're going to go to satisfy those outstanding judgments that are sitting out there as a result of the bank. So you see what I mean? That can terribly complicate things. But as far as would a bankruptcy proceeding eliminate those judgments? That would be specifically for a bankruptcy attorney. Okay? All right? We good on this idea of general versus specific lien? I know it's a long description, but I think when you understand better what the difference is, you understand how the specific lien works, which is really important to us in this class. So, we say that specific liens represent the right to foreclose. As a matter of fact, that's the only thing that matters here, is the right to foreclose. Liens, the only reason they exist is foreclosure. If you look at a lien, if it's a coin and heads is lien, then tails is foreclosure. That's why we place liens. We place liens because we intend to foreclose. If we didn't intend to foreclose, we wouldn't bother placing a lien, because the only thing the lien accomplishes is the right to do what? Foreclose on the property. When your lender makes a loan to you, a mortgage loan, and they place a lien against your property, it's not because they have to, it's because ultimately they don't what? Think about it. They don't think you will what? Pay. They don't trust you any further than they can throw you out the front door of that bank. Why do they place this lien? Because ultimately they do not trust that you will what? Pay. If they trusted you would pay, they wouldn't bother with the lien.
And is it usually a specified amount of time?
It is usually a specified amount of time to pay the money back. The lien itself is not for a specified amount of time, because liens are appurtenant. And things that are appurtenant last how long? Forever. Now let's think about the meaning of that statement. See, this is one of those times where I say something, and then you say, oh, forever, forever, yeah. And then you get a question wrong. Demetrius is selling his property, and he has a lien attached by Bank of America to that property. Melissa is buying it from him for $250,000. Demetrius owes Bank of America $180,000. At the closing, Melissa gives Demetrius the $250,000, and title is transferred to her name. Everybody with me so far? Demetrius, so the hell with it. I'm not sending Bank of America this money. What's the status of that lien? It's attached where? To the property that who now owns? Melissa. Demetrius have any worry about that? Nope, not a care in the world. Does Melissa have any worry about that? Absolutely. Who better start making a mortgage payment? Even though it's not her loan. Even though she just paid cash for the property. She just paid him $250,000 cash only to find out that she now owes Bank of America $180,000. Ain't that an ugly reality? Because if she doesn't pay Bank of America, what are they going to do? What is the collateral on that property? The house. So, let's take that to its next logical conclusion. Now that we recognize that liens are pertinent and that liens transfer with the property, who better make sure there are no liens attached before she takes ownership of the property? Melissa. If she has any sense whatsoever, she will make sure that those liens are satisfied before she takes ownership of that property. Because as soon as she takes ownership, fleas come with the dog. And that lien is attached to the property, whether she wants it or not. Kelly's question is, the lawyer would do that. Matt Locke, who? What lawyer? The closing attorney. And so, who would probably be well served by hiring a closing attorney? The buyer. The buyer. So, in North Carolina, see, here's a test question. North Carolina, who does a closing attorney represent in the transaction? The buyer. They are there to protect the buyer's interest because it's going to be. So, is Melissa going to give $250,000 to Demetrius, or is Melissa going to give $250,000 to her closing attorney and say, you satisfy the liens before you give him 1 red cent? Which way do you think it's going to go? She's going to give it to the closing attorney, and the closing attorney's not going to give Demetrius $250,000 and say, oh, you remember you have to pay off this loan. What are they going to do with it? They are going to deduct that $180,000 from the proceeds, and they are going to. So, does the closing attorney have an important function in this state? Absolutely. Can you do a closing without a closing attorney? Sure. You should be hitting the head with a brick. Maybe you already were hitting the head with a brick if that's what you're doing, because it's really stupid. Does that you see why now? That's why I like to give you that kind of a scenario, because now you understand all of a sudden what the importance of a closing attorney. I ask people all the time, what's the importance of a closing attorney? Oh, they handle the closing. Baloney. What's the importance of a closing attorney? They guard the what? The interest of the buyer, and specifically the M word, the money. They guard the money. When you go into that closing, the money's not changing hand between buyer and seller. All the money's changing hand between buyer and attorney. And that attorney's not going to pay anybody until they have personally satisfied all of those liens and cut those checks, and they're only going to give the seller the difference, what's left over. Because otherwise, Melissa would be taken into faith that Demetrius would do what? Pay that lien. And I don't think she trusts him that much. I certainly wouldn't. See, ultimately, you have to get to a place to understand the whole framework of law exists because you can't trust people. We hate to say that. We hate to have that cynical view. But is that not why do we have contracts? Because you can't trust somebody to do what they say they were going to do. Because the only time a contract matters is if they don't do what they promised to do, and you take them where? To court. And so things like liens, when we talk about these specific liens, they're there because some creditor did not trust a borrower to pay. Because they thought, if they don't pay, I need something of value that they own that I can do what? Take from them and sell to get my money back. You want to really break it down to what a mortgage is? How many of you have ever been in a pawn shop? It is no different. It's no different, right? You know, if you go into a pawn shop, you generally walk in the door with what?
Collateral.
Something of value, right? Collateral. And you're asking the pawn shop to do what?
Hold it. In exchange for
Loan you money. And in exchange, and before they will loan you the money, what do they have to do? They have to look at the thing of value and say, what is that worth? What is the value of this thing that you're giving me to hold as collateral, right? And they come up with a value of it, and generally, do they lend you the full value of it? No, they don't. And guess what? And guess why they don't lend you the full value of it? Because they're anticipating you won't do what? That you won't pay them back, and therefore they're going to have to do what? Sell that thing and be able to get their money back. Does that make sense? That is the mortgage industry described in 30 seconds or less right there. It works exactly the same way. Oh, we put fancy words like underwriting and appraisal and all that sort of thing. It is no different than going to your local pawn shop. You walk in the door with something of value. What is that case? What is that in the case of a mortgage? A house. And they look at that thing and they decide what it's worth. We call that an appraisal. And then they loan you some lesser amount than that. We call that a loan-to-value ratio.
They ain't gonna check your credit.
Right? They do check your credit. They do check your credit. They're a little bit more strict in that regard. But once they've established what the value of the thing is and what they will lend on it, then they take the thing as collateral. Well, in a pawn shop, they actually hold the thing because it's something portable. With a house, they can't actually hold the house. So what they do is they place a lien against the property, which gives them the legal right to take it and sell it if you do not pay. How do we feel about that so far? Good? That help?
Yes.
All right. So we're going to talk about the different types of specific liens because they do come in different varieties. Mortgage liens are not the only one. So we want to talk about the different ones. Let's talk about mortgages first, though. These are examples of voluntary liens. Now, we got 2 whole chapters later on in the book on finance. So we're not going to delve into how mortgages work right now. But these are voluntary specific liens. What do you think we mean when we say they're voluntary? You choose, as the owner of the property, to borrow money and to have what? A lien attached to the property. You are volunteering that property as collateral. Because we're going to talk about some of these that are not voluntary. There are examples of specific liens which are not voluntary, which you had no say in placing on the property. But this one is a voluntary one. It's a voluntary one because the borrower is walking in and choosing to take out that loan and saying, yes, you can place this lien against my property. All right? And the borrower is promising to repay that or have their property taken. That's an example of a mortgage lien. Now, we also need to talk about another type of voluntary lien called a mechanics lien. Not this kind of mechanic, though. Not a car mechanic. These kinds. The ones that are working on real estate. The ones who are doing work on real property. Give me examples of people who do work on real property. Contractors. Get more specific than that. Plumbers, electricians, drywall, painters, roofers, HVAC repair people, framers, landscapers, inspectors, concrete service providers, a handyman, anybody who does any kind of labor on a piece of real property that you own is covered under the mechanics or materialman's liens. Okay? They're sometimes called materialman's liens, but we call them mechanics liens in North Carolina. So anybody who does work on your property, how many of you have ever had work done on your home or major work done on your property? What's one of the first things, if they knew what they were doing, what's one of the first things they do when you're signing that contract? They make sure you what the property? You own it. They make sure you own it. Because if they can prove that the owner of the property hired them to do the work, and then they're not paid for the work, what do you think they have the right to do?
Foreclose.
They have the right to file a lien, which would ultimately lead to foreclosure. Here's what you don't want to accept. Can your landscaper foreclose on your house?
If you don't satisfy it.
Yes. Absolutely and unequivocally yes. And you got to get this stubborn mess out of your head. And then guy put a rose bush in. He can't foreclose on my house. Yes, he can. If you don't what? If you don't pay them. And see, that's what I mean in this class when I say you listen to me and you regurgitate the answer, but then you don't apply it.
Right.
They're going to intentionally give you an outlandish example. They're not going to ask you if the guy who built your house has a right to foreclose on it, because that's too obvious. They're going to ask you about some nonsense like somebody planting a rose bush in the front yard. Can they foreclose? Yes, because they did work on your property and you did not pay them. They have the right to foreclose if you don't pay them. That's the whole point of a mechanics lien. Go ahead, man.
Are they expressed or implied?
They are express.
Okay.
They are express. They have to be clearly laid out. Right. You have to have a written
So I
contract.
can't just tell my landscaper, you know, like let's say he and I have an agreement and he doesn't plant a rose bush, I could just tell him to kick rocks. He doesn't have any.
Correct. That's exactly right. These would have to be in writing. These would have to be in writing. And generally speaking, they need to warn you in advance in writing that they are reserving the right to place such a lien on the property in the contract that you sign. Okay? So if you've ever had a deck built or something and you sign a contract, that usually there's going to be language in there that makes it clear that they have the right to attach a mechanics lien if
Well,
you
they
do not.
choose not to sign the contract, they can still do the work, you're screwed, because,
If that doesn't sign the contract, you don't have the right to the lien.
right.
That's exactly right. All right? So, let's talk about the rules about these mechanics. Does everybody understand what one is? Are we good on that? Good on the basic definition. So these are people who are doing work on your property and they didn't get paid, so they have the right to do what? To foreclose, ultimately. Place a lien, and then, because the only point of a lien is to do what?
Foreclose.
Foreclose. So, let's talk about the rules. And you have to know these time periods. Goes into that category of things that are going to be on the state-specific portion of the exam. Last week we talked about the North Carolina Condominium Act, and I said that's going to show up in the state-specific section, right? Just as a quiz. What kind of condos does it apply to?
Brand new.
New construction, right? New construction condos. And what happens when you buy a new construction condo in North Carolina? You have 7 days to what? Rescind the contract. Change your mind after you've signed the contract, right? Okay, good, good. So this is another example, one of those things that's North Carolina specific. This is the North Carolina mechanics lien law. In this state, you have 120 days from the time you finish work on the property to file that lien. From the day you finish, a 120-day clock is going to start to tick. So whether it's an HVAC repairman or a landscaper or a plumber, it doesn't matter. From the last day they finish, from the day they walk off that job, the clock starts to tick and they have how long to go to the courthouse and file this lien? 120 days. Does that make sense for everybody? Now that's not 120 days to foreclose, it's 120 days to file the lien. Is everybody good with me on that? They have 180 days to foreclose. That's what enforcing the lien means. So 180 days from the time they finish the work to actually foreclose on the property.
So why is that worded a little differently? It says 120 days from last furnishing of labor or materials. And then it says 100, this screwed me up on the test last time, that it's within 180 days of furnishing of
Yep.
labor or materials. But I thought that with the 180-day clock, it was from the initial furnishing.
No,
Is that
it's from
plain
I'm going to talk about that in just a second. I know where your confusion is, and it's where I'm headed. Okay, so bear with me a second. What I'm going to do is get out of here for just a second, and I'm going to draw you a little timeline because I find that a timeline is helpful here. All right. That's what I'm looking at. So. Let's take just a little timeline like this. And we'll say today, what is today? January the 14th? Okay? So today, our heat broke. Is that a problem?
Yes.
It's a little chilly tonight. Right? Does it snow again this week? I'm flying to Arizona on Thursday. Of course, if it snows on Wednesday, I may be sitting at RDU crying. So, we need a new HVAC system. Let's say we find somebody today to come out and install it. I know that's pie in the sky thinking, but let's just assume that today we need a new HVAC system and they have installed that thing. Everybody good with me? So now, how long does that service provider have to file a lien against my property if they want to, if I do not pay them. If it's done today, 120 days from today, which is 4 months, right? So it'd be February, March, April, May 14th. Everybody agree with that? So February, March, April, May 14th. So 5/14. Right here, they must file lien. Does that make sense for everybody? And if they want to foreclose, they have 180 days. So that's going to be June, July. Everybody okay with that? So June, July, 7/14. This is the date by which they must foreclose. If they're going to. Now, before I get to your question, let me explain something here. They do not have to foreclose. The lien is a pertinent, which means it lasts how long? Forever. Mechanics liens are interesting though because they have a limited amount of time where they can actually be foreclosed upon. So they can only foreclose if they do so within the first 180 days. Even if they choose not to foreclose, and quite often most mechanics liens are not foreclosed on. If you can imagine, most HVAC people are not into taking houses and selling them, right? Even if they choose not to foreclose, the lien is going to stay there, and it's eventually going to be satisfied. When Melissa buys that house from Demetrius, what did I say it would be in her best interest to do?
Get a lawyer.
Get a lawyer, and what is that lawyer going to look for?
It's going to be free.
All the outstanding liens on that property, and make sure that they are all what? Satisfied before we transfer title. So what's the ultimate answer to when this HVAC system is going to get paid for, if not before?
Whenever she sells.
Whenever Demetrius sells that house. That lien's going to sit there. And whenever Demetrius sells that house, that closing attorney is going to make sure that lien gets satisfied as a result of that sale. Because the buyer's not going to want to take title with that lien still attached. Does that make sense? Everybody follow that? Go ahead, Sharon.
So the mechanic, the person that's doing the work, when they file the lien, they really don't have to go to last step because it's gonna get satisfied.
Eventually.
Yeah.
Correct. They do not have to foreclose. They have to file within 120, because if they don't file, they've lost their right to collect.
Right.
Does that make sense for everybody? But as long as they file that lien by May 14th, eventually they will get paid, most likely, when the property is sold down the road. Everybody with me on that? Okay, go ahead,
So
Kelly.
let's just say, for example, this is a company that you owe them $100,000, they've done some big work.
Yep.
Now, if someone in that company wanted to take the process of going through the foreclosure, they didn't want to wait on their money until
Sure.
it's sold in 10 years, they could foreclose on your house, and the company would own your home, and they would be able to sell it?
They don't own it. They take it and do what with it? Sell it. Foreclosure is not me taking ownership. Foreclosure is me taking it from you and selling it. I am not taking ownership of that property.
So they would have
When
to
I-
market it and sell it?
No, they would not have to. The courthouse would.
court,
Where do
okay,
foreclosure
okay.
sales happen?
The courthouse.
The county courthouse.
Okay.
The county courthouse. So what they would do is go to the county and say, take it and sell it. Take it from them and auction it, because I have this lien.
And, wow, okay. And even if it's a small lien for like $10,000.
$50 if you don't pay it.
Exactly.
You gotta pay it. That's exactly right.
Sometimes you don't even know.
Sometimes you do not know.
Sometimes you don't.
Sometimes you do not know. Sometimes people have mechanics things that they're unaware of.
And I know that doesn't pertain to this, but that's what I don't understand, is how that can
They could potentially have. Pat, I see your hand.
So if the court actually takes the property and sells it to satisfy this $100,000 mechanics lien, and if they sell it for $200,000, that extra $100,000, does that satisfy, or is that applied to the mortgage?
Well, hold that question, because we're going to talk about lien priority. It's coming.
Okay.
I'm building up to it.
Oh,
You know?
sorry.
These liens are going to get paid in a certain order. No matter who does the foreclosing, we have what we call priority. You know, like you get seniority, right? Priority is the same thing. People have a certain place in line with these liens, and that place in line is very important.
be. So what we need to remember is the 120 days to file the lien and 180 days to foreclose.
Yes.
So we don't need to worry about I got mixed up.
Hold
with the
on,
last
you
name
do
of
need
the
it. Yeah.
Okay.
Hold on. Yeah, you do need that, but I'm gonna come back to it. That's Pat's original question, and I have not forgotten it. And I'm gonna get there, right? Because there is something to do with the first day of work too. Okay, go ahead.
So what if you have like a surveyor that surveyed some land? for a contractor that is about to sell the property, do you have 120 days?
So the contractor is the owner of the property,
Mm-hmm.
and they hired
And he
a
don't want to pay.
they hired a surveyor and they don't want to pay. Is that work done on the property?
Yep.
You better believe it. They have a right to file a mechanics lien within 120 days of when they did the what?
The actual
The work,
survey.
the actual survey. So whatever day they visited the property, do you have it on a surveying company? That feels like a very personal question. There was an edge in that question, like, this asshole don't want to pay me.
The guy that has the land and is building the house, he was like, I'll pay you all
Of
when we
course he
sell
will.
the house.
Yeah.
And I made a phone call and now he don't use us anymore, but that's fine. I mean, but he needs to pay his bill.
Yes, and you can file a lien for that. Do you have a signed contract on the, so yes?
So how can you get around it if you don't have a signed contract? You're screwed?
This
guy has been
I can't really answer that question because I'm not a magistrate who would be issuing these things, but my understanding is, generally speaking, you have to have a signed contract to prove that the owner has authorized the work.
And that's why he was blatantly just refuses to sign it. He's just an asshole.
Does happen. Does happen. We have a whole court system to deal with them. That's why this thing, you know, like.
So it would be a mechanics.
Can you collect interest on that? Yes, you absolutely can.
And penalties.
And penalties and legal fees. Because remember, this foreclosure is not going to happen for free. Like, you have to hire an attorney to go file this lien. There's a cost of filing the lien. All of that gets tacked on to the lien amount. So something that was a $50 rose bush could become a $15,000 lien.
To include
Kinda like
grievance.
the refrigerator, but it's not
Yeah. Is everybody okay with this so far? Now, I want to look at this timeline again, but I'm going to complicate it a little bit here, okay? I'm going to add, and I'm going to try to do it with different colors. So far I'm so good, but we'll see if the different colors continue to show up there. Sometimes it gets washed out. Let's say that on, so we have a calamity and the computer falls down. Let's say on December 14th, February 14th, Valentine's Day, we had something else go wrong in the property. Give me something else that might need to be fixed. A roof, a leak, maybe? We got a leak. Furnace blows up. We just got a new one. I hope it. We haven't paid them for it yet, but it's still in warranty. Hopefully they will come and fix it. You know, like, a water pipe busted, right? Okay, all right. So there we go. Even with my new furnace, my water pipe busted. This is a heck of a house we've got going on here. My sprinkler system. Okay. Well, we have a frozen pipe. We have a plumbing bill of some type, right? All right. So we have a plumber. And we owe him, let's say the HVAC system over here was $7,500, okay? And then we have a plumber here that we owe $1,500 on 2/14. We good there? Can you see the difference in the colors? I'm trying to differentiate things for you, all right? Now, how long is the plumber going to have to file his lien? He's going to get the same 120 days. So he has out here till what, 6/14 for the plumber? We'll just put P right there, 6/14 for the plumber to file his lien. And he has until what? 8/14 to foreclose, right? Does that make sense for everybody? Because his calendar's different. When and if, let's say, we never make it to foreclosure on any of these things. Let's say we get a foreclosure sale. Not a foreclosure sale, just a sale. We won't complicate it with a foreclosure. We just say we have a sale that happens right here on June 30th. Sold. The property is sold on June the 30th. Does that make sense for everybody? So we're going to make the assumption that both the HVAC system and the plumber have filed their liens, but I'm going to put a wrinkle in here. Let's say the plumber had until June 14th, but he filed his lien way back here in the middle of March. All right? Now, the plumber filed his lien first. He filed his lien before the HVAC repair person. Does that make sense? When this property is sold, who's going to get paid first?
Plumber.
Not the plumber. Not whoever filed first. This is the only lien, and you ought to write this down in your notes. This is the only lien that is not paid in the order it's recorded. It is paid based on the order in which they began work. Who started their work first? The HVAC. So who's going to get paid first? The HVAC. That's the only thing that relates to when I began work. Everything else is keyed off of when I finished. The 120 days and 180 day clocks both are when I finished. But when it comes time to pay those liens, they're going to look at who actually performed the work first. And here's why that's important. Think of a sale as a bucket of money. If we were all sharing the same buffet here at lunch today, would you want to be at the front of the line or would you want to be at the back of the line? Especially if you knew they were only stocking the buffet one time. Would it be more important to be at the front of the line or at the back of the line? Because if you're at the back, what could happen? You ain't getting nothing to eat. And it's the same thing with a property sale. How many times do we put money in the bucket when we sell the property? Once. Does it matter what order you're in to get paid? Yes, because they might run out of what? Money. That's why we care what order these liens are satisfied in. And when we talk about mechanics liens, the order we satisfy them is not the order that they were recorded, but rather the order that they did what? That they started work on, not the order they finished work. The order they started work on the property.
So in this example, let's just say just the HVAC.
Yep.
They started the work on the 14th and they finished it on the 19th. So reading this, it's, you go ahead and file still on May 14th.
Okay?
No, you would file it on May 19th.
May 19th?
Wait a minute, which one's the black one?
That's the HVAC. I just said they started and finished on the
But it's
14th.
effective from the day that the work first started.
Started. So we didn't file it out here till May the 14th, but if you look at the date of that lien, it's going to show as 1/14 because that's when they started the work.
Right, but you were talking about a same day, so let's say that there's a 5-day spread, because when I read this, sorry to complicate this, but it says a person claiming a mechanics lien must file the claim within 120 days after last finishing
The work.
labor or materials. The lien takes effect
The day they
from the
began.
that they first provided.
That they first provided. So say it took them 5 days to put it in, right? It started on the 14th, they finished on the 19th. Their 120 days would start from the 19th, which is the day they finished, but it would show as filed on the day they started.
Okay,
So that's what it is. Say that again, say that just again.
Their clock starts to tick when they finish.
Right.
So the 120 days and 180 days, that starts the day they finish work. Because remember, a lot of these things are not going to be same-day jobs, right?
Right.
If you think about like a plumber on a new construction house, they might be working over the course of 2 months on that property, correct? So when is their 120 day going to start? When they started or when they finished? When they finished. They're into this thing for 2 months before their 120 day clock even starts to tick. Does that make sense for everybody? So now we're counting down the 120 days. They file the lien. What's the date that's going to show on the lien? Is it going to be the date they filed it, the date they finished work, or the date they started work? The date they started the work is going to show as the date the lien was filed. So basically it gets filed retroactively. When you file it, it's filed retroactively to the day you started doing the work on the property.
Which makes sense.
Does that help when I say that word retroactive?
Yeah.
Do you understand what I'm talking about there?
Yeah.
Okay? Yes, Dave.
Travis, and you said that's the maximum they have to file. They can file.
They can file the same day.
Yeah.
They can file the same day.
Right.
Absolutely. Now, many of them don't, and here's the reason. There's a cost associated with filing the lien. And you can't make the person you're billing responsible for the cost of the lien unless they actually don't what? Pay you. So if you run out and file that lien on day one and it costs you, I think in Wake County it costs like $200 to file a mechanics lien if you do it yourself. It's like $195 if you do it yourself. Well, if you go out there on day one as the HVAC company and file a mechanics lien, and next week they send you a check, you just lost $200 because you spent $200 filing a lien, which they immediately did what? They immediately paid, and now not only do you have to pay you're out the $200, you got to go back to the courthouse and satisfy that lien, because if you don't go back and satisfy it, they could sue you for having an illegitimate lien against their property. So it's not something you want to just instantly do. You want to really make sure somebody was. So what most service providers would have is a contract that says this is a 30-day net, right? And after 30 days, we're going to file a lien on your property, and you would also be responsible for any late fees plus any filing fees at that point. Because couldn't you have a written contract that says if they don't pay you within 30 days, then they're also responsible for the cost of filing the lien, even if they pay the lien, right? Even if they pay, they still got to pay the filing fee. You could have a contract that says that.
Travis, you went a little confused. So you said your 120 days count starts from the day they finish the work.
Correct.
So let's go back to your HVAC scenario.
Okay.
So the work started on 114.
Yep.
And work finished, let's say hypothetically 120.
Okay.
Now your 120 days starts from 120, so that would be they can file on or before 520.
Correct. And when would the lien show as effective? As long as they file it before 520, it would show as what date? 114, which is the day they started the job. Okay? How would we feel about this? I know those timelines can be a little bit confusing, alright? Everybody understand why the order is important?
Yeah.
Good. That helps back?
Yes, good, thank you.
Good.
I should get that right.
That's always the hope. Okay? Alright, so remember we said that all liens, all these specific liens are pertinent. They run with the property. They don't attach to the owner. These things attach to the property itself. Therefore, they transfer with the property. They stay there until satisfied. About the only thing that's going to eliminate a specific lien other than paying it is a foreclosure action. The foreclosure action will eliminate all the specific liens on the property. So when you buy something at a foreclosure sale, you are buying it without those liens. They have been stripped away. Okay? Everybody with me on that? Okay? At least the inferior ones, the superior ones that we'll talk about. Alright? So, let's talk about priority. Lien priority is a very important thing. Think of the buffet. I don't want to be at the end because I'm hungry. And they may run out of food. This is what happens whenever a property is sold. And a foreclosure is a sale, by the way, right? What do we do when we foreclose on the property? We auction it off, sell it, because we want the money to satisfy the lien. So any transfer of ownership is going to involve this lien priority. And this is very important because this is the order in which creditors are going to get paid. This is a law. It's a state law. So if the state is creating a law saying people get paid in this order, who do you think the state is going to put at the top of the list? Themselves. That's exactly right. So number one on the lien priority list, real property taxes and special assessments. So in any sale, whether it be a transaction between private parties or a foreclosure sale, what's the first set of liens that are going to get paid if they are outstanding on the property? The property taxes, any property tax liens. They are what we call superior liens because they sit at the very top. A superior lien is one that sits above something else. So real property taxes and special assessments. What did we say a special assessment was? You remember that when we talked about that? So a homeowners association or a city or a municipality has decided to do what? What's the word I'm really looking for? Well, they improved my property. That's the magic word with an assessment, right? They have improved my property. Well, because they improved my property, what do they have the right to do? Make me pay for it. That's exactly right. And that special assessment is going to float all the way to the top. Notice what's here in the middle. Mortgages. So what does that mean about special assessment liens? They get paid what? First, before the mortgages. Property taxes get paid first before the mortgages. Does it matter that the mortgage was recorded before the special assessment?
No.
No, because what we're saying here is that any outstanding property tax liens and any outstanding special assessments will get paid first, no matter how old or new they are. Does that make sense for everybody?
Yeah.
That's the first money out of the bucket. So, I want you to start thinking of it this way. If you have a lien on a property, and you're thinking of foreclosing, that means you're thinking of doing what? Forcing the sale. I love that description. Tom said forcing the sale of the property. Because I really don't want to think of it as me taking ownership, because I'm not taking ownership. If I'm foreclosing, I am telling the court to do what? Take it, auction it, and give me the money. But if I'm looking at foreclosing, might I better look up and see who's above me in the food trough line? And make sure that I can always sell that property for what? At least enough to pay them first, and then me. Could an HVAC, where's mechanics liens on this list? All the way at the bottom. So if I'm the HVAC guy, and I'm going to actually foreclose on this property, don't I need to be relatively assured that the foreclosure action is going to bring enough money to pay off any property taxes and special assessments? And then any what? Mortgages, plural, if there are more than one. And then what?
Any other mechanic.
And then finally me, and that's assuming I'm the only mechanics lien, because could there be other mechanics liens that would be superior to me as well?
Sure.
If they did what before I did?
Or did work before.
If they started work, not filed, not did work, if they started work before me, because remember the order they're going to get paid in is dictated by the order that they started work. So if I'm that HVAC guy, I'm way at, I can't even see the front of the line from where I am in most of these properties. Is that correct?
So you can run us like a title check or?
You can do a title check, let's see. And so do you think if I was a really good, had my stuff together HVAC company, I might go do a title check before I did work on that property to see what kind of liens were outstanding on that property? And if I look and that person owes more than I think the house is worth, no, we require a credit card before we can do this kind of work for you. Does that make sense for everybody? Because you got to know what order you're eating in. And if you're the mechanic, you are eating last. Absolutely last. And by the way, with mechanics liens, you never really can truly know what order you are actually in, because even if you filed your lien, could there be other liens that get filed after yours that actually get paid before you?
Yes.
Because if they started work before, like you mentioned concrete, right? On a new construction house, the person who does the concrete is probably the same one who does the foundation, and then comes back and does what at the end? Driveway and sidewalk, right? So if they're filing a mechanics lien on that property, they may be the last ones to file, but the what? But the first ones to get paid, because they started work before everybody else did. You see how that works? They may not file their lien until 3 months after the house is built, after all the other people have already filed their liens, but when it comes time to get paid, excuse me, front of the line, excuse me, because they started work first, because they put those footers in the ground before anybody else came and worked on the property. See how it works? Is that important?
Yeah.
You better believe it. Absolutely. Especially if you're looking at filing one of these liens. Okay? How do we feel about this? Good. Understand why we have priority? Okay. Now, within these levels, so like mortgages, if we have more than one, what order are they going to get paid in, do you think?
First one.
That's why we call them first, second, third. The order they are recorded in. That's where we look at the order, and that's where the order matters. You know, but we don't pay, for example, mechanics liens ahead of mortgages. No matter how old or new those are, mortgages are always going to sit above mechanics liens. And that's why when you go refinance your house, they don't care if you have mechanics liens, because they know they're going to get paid what? First. They know that they're going to get paid before the mechanics liens, right? So if you go to refinance your house with Bank of America, you could have 20 mechanics liens hanging out there, and guess what? They don't care. because they jumped the line because they're a mortgage, and mortgages are going to get paid before them. How do we feel about that? Good? By the way, mechanics liens are always an issue because of this timeline. Think about the ugliest thing you could possibly imagine happening. How long, first of all, do these liens attach to the property or the people who own the property? The property. Everybody agrees with me on that, correct? They attach to the property. And how long do these service providers have to attach this lien to the property? We just talked about it. How many days? 120 days from when? When does the clock start in? From the last day of work. Is there any like caveat or exemption in there for if the property gets sold sometime during that period? There's not. So let me give you a little scenario here. Carolyn buys a brand new house. Brand new. New construction. Beautiful. $480,000, because Carolyn's got it like that. She buys that house and she moves in. And a month after she moves in, the letters start from the Wake County Clerk of Court. A materialman's lien has been filed against your property from an electrician. The electrician who did what? Who wired the house. And the next day another one comes from a plumber. The plumber who installed all the plumbing in the house. And the next day from the framer. What does Carolyn come to quickly realize? The builder she bought the house from never did what? Never paid any of the subcontractors. Whose responsibility are all those liens now? Carolyn's. Because who owns the property? Carolyn does. Could Carolyn buy a brand new house and have hundreds of thousands of dollars of mechanics liens attached to it after she purchases it? Absolutely. Absolutely. Now, what's the best way that Carolyn could protect against something like that? Nobody does this, but what's the best way to protect yourself against it? Wait 120 days. Go look at the house and say, it's perfect. Don't touch it. For how long? 120 days, because if she waits 120 days to close, does she run the risk of having any liens filed against that property? No, because even if they hadn't been paid, they've lost the right to file the lien because they're more than 120 days from when they finished work. Now, do most people want to wait 120 days after the house is finished? Should they understand they're taking some risk by closing within that time frame?
Well, not necessarily, right? If you have a lawyer, not necessarily.
Oh, a lawyer eliminates all risk. I mean, most people in prison have lawyers. I hate to tell you. Doesn't it minimizes? Now, I'm not trying to diminish that. Does it minimize risk? Yes. It doesn't eliminate it. There is only one foolproof way to eliminate this risk. It is to wait 120 days from the time you view the property to the time you close. And by the way, does that extend to resales, not just new construction? What do most people do when they get ready to put their house on the market? Fix it up. Could all those people who have done work on that property potentially file mechanics liens against the property even after the sale happens? You better believe they could.
So, would the buyer be protected by title insurance?
Title insurance would indeed protect the buyer in most cases, but title insurance is slow to unravel. And by the way, we had this happen. When the market collapsed in 2008, there was a builder based in Raleigh here called St. Lawrence Homes. Have any of you ever heard of St. Lawrence Homes? St. Lawrence Homes went bankrupt. And they had about 150 homes in various stages of construction when they went bankrupt. I mean, they literally stopped. One day they were building, the next day they were out of business. There were 33, I believe, homes that had closed in the 60 days prior to them going out of business where they had never paid the subcontractors. And those 33 ended up with hundreds of thousands of dollars worth of mechanics liens filed against them. And all those people had title insurance, and some of them still don't have those sorted out completely. Those are still contentious cases out there. So it could, yes, you could have insurance against it, but it could take years. Now, one of the protections we now employ is we have a waiver signed. Because of St. Lawrence and because of what happened there, when you buy a new construction house now in North Carolina, if you have a closing attorney, they are going to say, we want every subcontractor who did work on this property, we want a list from the builder of every subcontractor who did work on this property. So that the attorney can contact every single one of them and get them to sign what before we go to closing? A waiver. And what does a waiver do? It says, either I've been paid, or if I haven't been paid, I waive the right to do what? To file a mechanics lien against this property. Does that make sense for everybody? So could you have somebody do that? Now put yourself in the role of a real estate broker. When you show a house, and you walk in and you see a brand new kitchen, what should you ask for? Receipts. Receipts. I want to see paid receipts. And then when I see them, am I going to call the service provider and follow up and ensure that they have been paid? Yes, and not only that, I'm going to provide those receipts to the closing attorney so they can draw up a waiver and send to that service provider and get them to sign it. Because that's protecting my client, the buyer, right? Otherwise, the only other protection is to wait 120 days. We see the house, it looks beautiful. If we make an offer and go under contract and have our closing be 120 days from now, we know we're golden. And by the way, I do say that to my clients. I know they're going to do what? Ignore me, because they're not going to 120 days, wait 120 days. But have I done my job by advising them that the best course of action is to wait 120 days? They're not going to do it. So then I talk about all those things that would mitigate this risk, that would lessen this risk. But the only way to eliminate it is to wait 120 days. See what I mean? I like to tie it back to a real world something, so you see it's not just something you have to memorize for a test. It actually does matter in the real world. How do we feel about a mechanics lien now? Pretty good? Good. Good. Hopefully you feel like you don't want one. If you get to that point, then we're where we need to be. Okay? We also mentioned deed restriction. Oh, I'm sorry. Go ahead. Remember your name. Hassan, that's right.
Might wait more than 120 days, depending on when.
I thought he said might weigh more than 120. He said wait. Okay. I'm like, I weigh a lot more than 100. Sorry, might wait more than 100.
Yeah. Depending on when the service was finished. So you said like wait 120 days, but it all depends on when was the last service.
Correct, but if I wait 120 days, I know it doesn't matter anymore. I know I'm outside the window. Does everybody understand the question? He's saying, I don't know when they finished work. So I don't really know when. It may have already been 60 days. But to be absolutely safe, from the day I see it, the work's already been done, and then it doesn't change for the next 120 days, we know we're in the clear. Does everybody understand what I'm saying there? If I look at the property today, here's the condition. We write the contract today, and we close 120 days from now, and the house is exactly the same then as it was now. I know there's no possibility of a mechanics lien being filed. Because if they haven't been paid, they're outside of their window of when they could file the lien. Again, that's the safest approach. Not going to be always the most practical one. Okay? Yes?
Will the seller wait 120 days for you to close?
Well, again, that would be a part of the negotiation. The question was, would the seller wait 120 days? Would that probably diminish the attractiveness of your offer in a market like this? Absolutely. No question. And that's why, again, the perfect answer is not always the practical one. But it's not. Here's where real estate brokers get in trouble. This is a very real world concern, and this happens all the time. Real estate brokers don't get in trouble by exposing their clients to risk. We get in trouble by exposing our clients to risk without their knowledge. Without saying to them, you should wait 120 days, and here's why. And let them make the decision. Because then they're going to naturally ask the question, well, is the seller going to be willing to wait? What do you think my answer is going to be? Probably not. And so then we move on from there. But I've at least done my job by letting them make the decision. Because if I never mentioned to them, how many of you are super careful? You're that type C personality. I could have guessed. Pat's going to raise her hand. So if she's that careful person, she wants the ability to make that decision, right? You want me to say to you, here's why you should wait 120 days, and then you can weigh out the risk of that. Is that a fair assessment of how you? That's a pretty fair assessment. Would you be upset, even if you would have ultimately decided to let's move ahead and close, would you be upset after the fact if you found out that there could have been a lien filed against your property and you never were aware that that could have been the case because I just glossed past it and didn't say anything to you? Would that upset you? Absolutely. You see what I mean? And being upset, that might be the basis for a lawsuit if one of those liens actually did get filed, by the way.
So I'm really sorry to pound on this one.
No, you're fine.
You did bring up builders, and,
Mhm.
and so I have a special place in my heart for builders.
Is that like in a
I do,
sub-level
right.
of your
Some
heart,
are
or?
level and some are just, I don't know what it is. So I have this one contract where the buyer will be in default if the buyer doesn't use the builder's attorney. Likewise for the lender. But she's going outside of that, and she's using me. So now that you're talking about this waiver at settlement, and you're using a preferred attorney, how does that compromise the buyer?
Dramatically, in my opinion. Dramatically. I have always been, I'm one of those renegades out there that tells the buyer, this is BS. Do not use the builder's attorney because here's the thing, I have never once in my career pushed back against that and had somebody say, well, we won't accept that contract. I've never once sat down with that builder in that negotiation and said, we want to use our own closing attorney, and had them make an issue of it. Most people go along because it's written there in front of them and they assume they have to follow that restriction. Now, I have had builders say, well, we will pay for the closing attorney if you use ours, and if you use your own, you have to pay for your own. And I still look at my buyer and I say, who do you think you're going to be better off with? The one that the builder is so desirous that you use that they are willing to pay for it, or the one you're paying for? Which one do you think is going to be a better result? You know? And again, let the buyer make that kind of a call. But I've never in my career, and I've done a lot of new construction, I have never just taken at face value that we had to use the builder's attorney. Is it admittedly easier? Yes. Do the builders intentionally make it harder for an outside attorney to close one of their transactions? Yes. They, no question, and you've experienced that, I'm sure. They do. They don't want to deal with you. The reason they don't want to deal with you is because, like it or not, the buyer's not getting as much protection by using the builder's attorney, because it is rubber stamped, moved along. At those closings, there are things that other closing attorneys would point out as risk that those attorneys do not point out. And I have been on that side. I have seen it. I can't really do anything about it at that point, but I have certainly seen it. And I always, as a buyer, I would never use the builder's preferred attorney. I would not do it. I would hire my own attorney.
So what happens if I find that out after I close the house? Can I find my own lawyer and sue on the lawyer of the builder?
No, because you agreed to use that attorney. I mean, again, you know, you opted to, that would be the way it would be phrased, that you opted to use that attorney for whatever reason. Most likely that the builder paid for it. That would be the reasoning that they would say, well, you used us because we were free to him.
Some of the contracts say there's no recourse. I mean, you can't hire an attorney and sue them.
Right, and that's another, and that's another reason to, you know, even just builders' standard contract language. You know, one of the things I always recommend to buyers who are buying new construction is to, if you're going to use an outside closing attorney, get them involved early and let them actually review the contract so that they can point out the gotchas. Because you take a builder's standard contract, a national builder, Toll Brothers, KB Homes, Syntex, MI Homes, you're talking 70 or 100 pages for that contract. You as a real estate broker have no business trying to read and evaluate that thing. You know, they need to have an attorney do it. Does that cost some money? Sure. But again, let the buyer take on that risk. Can you say to the buyer, if I were you, I would have an attorney review this. And say, okay, well, how much is that going to cost me? Well, you know, the attorney says it'll cost about, you know, they'll charge you, their normal cost for closing the transaction is $1,000, but on new construction they charge $1,500, and that includes reviewing all the documents before you sign them. And the buyer says, well, I don't want to pay that much. Who made the choice? The buyer. And that's the important thing for you to understand. You cannot force your clients to do anything in this business, but you should always advise them in their best interest. We get into trouble as real estate brokers by not giving the advice. That's the problem that we run into, because we make the assumption, well, I know what they're going to do anyway, so there's no need for me to say it. Yes, there is a need for to say it, because it needs to be their choice. Like when you're presenting offers, if you got 4 offers and one of them came in on the back of a napkin written in crayon, do you just throw that one away and not present it? No. You presented them. Now, do you say to them, I don't think this is a serious offer because it's on a napkin in crayon? Yes. But you let them make the choice. That, if you don't learn anything from an actual practical standpoint in this class, it should be that. Always let the client make the choice. Provide them with the options. Our role is to advise and present, not to choose. That's not our place. And so many brokers do it, even without realizing they're doing it. with attorneys. How many brokers do you think, how many of you bought a house? How many of you actually feel like you chose the closing attorney? Look at how many fewer hands went down. How many of you just used the one that your buyer's agent said, this is your closing attorney? That shouldn't happen. That should not happen. They should say, listen, ultimately, we all know that most of the time the buyer's agent is going to be the one choosing the closing attorney, because most of the time the buyers have no idea who to use, and they rely on us for that advice. But we've got to at least give them the option. We've got to say, now, do you have a closing attorney you would prefer to use? They may look at you and go, what's a closing attorney? And that's okay, because could you then provide them with a recommendation for a closing attorney? Sure. But I see so many agents who write up the offer and they just write in who the closing attorney is going to be without even having that conversation with the buyer. Here's the problem with that. Number one, it's not fair to your client. Number two, if that attorney makes a mistake, you could be held liable for that mistake because you force-fed that service provider to your... Does that make sense? You just chose. Well, if you chose, it's on you. The choice is yours. So is the responsibility. We'd love to think that everybody we recommend is always going to do a great job. Luckily, they mostly do. But again, let your client choose.
But in that case, even if your client chose the attorney and the attorney messes up, it's still on you, right? Because you have to double check behind the attorney.
No, I mean, for items of legal advice, I cannot be held to a higher standard than the attorney. Now, just like the attorney wouldn't be held responsible for the buyer overpaying for the house, because an attorney should have, they're not trained in valuing a home. I'm not going to be held responsible for how a buyer takes title, as long as I've given the basic advice. You should talk to the attorney about this, because the attorney is the higher resource than me. They're trained specifically in that, whereas I'm trained specifically in, is the buyer paying a fair price for the property? So the big thing is, don't take on responsibility. You got enough responsibility. Don't take on any more than you have to. Recommend the appropriate people where appropriate, but always leave it up to the client. Let them choose. Let them make the choice. All right. So before we take a break, I want to just talk about deed restrictions. Covenants. How many of you, several of you said you live in neighborhoods that have covenants, or restrictive, protective covenants, right? Covenants are an encumbrance because they limit what you can do with the property. This is another example of an encumbrance, and we have a whole chapter about them, so we're not going to speak in detail about them here, but they are appurtenant, which means they're going to stick with the property for how long? Forever. And they are encumbrances or limitations on use. You may see on the exam something called a lien pendens. It's not lis pendens, it's lien pendens. Or something called a writ of attachment. For your purpose in the class, they're the same thing. Legally, they're not actually the same thing. They have a distinct difference, but you're not expected to know the difference. So I'm going to talk about them as the same thing. A writ of attachment or a lien pendens, both are legal stops. Don't buy this. They're warnings. They are, let's throw a wrench in these gears and stop them from turning. We're stopping a seller from selling the property. And the reason we're stopping a seller from selling the property is because there is an ongoing pending lawsuit that could impact the ownership or title of this property. In other words, the seller's being sued by somebody. And depending on how that lawsuit goes, the seller may not even own this thing to be able to sell it. Does that make sense for everybody? So, not that people would do nasty things like this, but if you were being sued and you felt there was a reasonable chance you might lose the lawsuit and therefore have your property taken from you, what might you be tempted to do real quickly? Sell it. Let me get rid of it, because let me get my money now, right? And run away to some non-extradition country somewhere. If I file a lawsuit against that seller, and one of my goals is to obtain ownership of the property or place a lien on the property, I can file what's known as a lien pendens or a writ of attachment, which basically is like a red flag on that property to any buyer that says what? Do not buy. Do not buy. Do not buy this because there's something bad hanging out there over this property. So that's what you need to know for a test. It's not really it's not the technical definition of a writ of attachment or a lien pendens, but that's what you need to know. Effectively, it's just a legal action to stop a seller from selling while there's a lawsuit pending. Yes.
Sorry. All right, so I had this happen once, and it was a foreclosure. It was a Deutsche Bank foreclosure, and
Okay.
the only way that you could write on the property was you had to actually bid for it online.
Uh-huh.
And what they would do is they would take it off the market and then repost it, and I shouldn't say take it off the market, but
Right.
if they couldn't get the desired price.
Right.
So
Was
it
it like
wasn't until the
Hubzu or one of those?
Yeah, so we weren't aware that there was this issue until after we had the ratified contract and the loan was in process, and when we got the title work, then we had, so you're saying that, would it then have been the prior homeowner that was suing Deutsche Bank, or Deutsche Bank suing?
It could have been, or it could have even been the prior homeowner being sued by a third party. It could have been the previous homeowner was, like, in other words, Deutsche Bank foreclosed while that legal proceeding was going on. Then it could have resulted in like a lien pendens or a writ of attachment, that Deutsche Bank's title was potentially impacted by, that thing. That help?
Yeah.
I mean, because in essence, if Deutsche Bank is foreclosing and then selling the property, but there was a lawsuit prior to the foreclosure action that could impact title, then Deutsche Bank can't really convey marketable title right now because there's this nebulous cloud hanging out there that still needs resolution. That's the idea.
It was resolved, I just.
Yeah,
I didn't know what-
and sometimes the title insurance companies, from your perspective, will what they call paper over it anyway, and if they will, then sell it. I mean, if they'll give you title insurance, go along.
Yeah, it
Go along
was.
to get along, right? Yeah, that's what happens. In the real world, if you can get title, we do all this talking about marketable title and what is marketable title and yada yada yada. If you can get title insurance, you're going to close, because ultimately at that point we've transitioned the risk off to some giant title insurance company in the sky, and we just move along.
I mean, they're the ones that take the blame.
They take the risk of the lawsuit. That's exactly right. That could, and the loss that could be associated with it. You buy title insurance just like the same reason you buy health insurance, in case you get sick, right? You buy title insurance in case some claim is made against the title of your property, that they will fix it. They will pay for fixing it. Okay, title insurance isn't that you won't have problems. It is that if they come up, somebody else will pay for them. That's what all insurance is, really. It's just, okay? I think it's a good time to take a break before we talk about easements. So let's take a break and come back in about 15 minutes and then we'll talk about some easements. Yes, let me stop that.